Friends, today's seminar divided into three parts: conveyance part, redevelopment part, and rather than guidelines under 79A, it is direction under 79A. Normally, we have observed that in many seminars, physically as well as online, guidelines are thoroughly discussed because that topic comes under the redevelopment. However, today's topic is not the guidelines per se, but the nature of 79A. What are the directives? What are the power of the government? Whether it is mandatory or directory. These questions has bothered one and all on this topic. Registrars pass any order, they give the direction to register a particular development agreement with a particular developer. Whether the registrar had the power to direct the society. What was the role when the registrar representative comes in a society in that general body meeting for the purpose of approval? Friend, all these issues are part of the nature of 79A power of the government. So, I will not deal with guidelines per se, guidelines of 2009 as well as 2019 will be dealt with by my co-speaker under the topic of redevelopment. I will purely deal with the nature of directive under 79A. Before we go to the precedent, I will make my talk as simple as possible without referring into any legal terminology or legal terms. I will start with what is 79A. Now 79A is precisely, it says that when a report is given to the registrar or the government by the registrar about some issues, and the government is of the view that that particular aspect need to have some public interest issue involved in it for the purposes of management of the societies, for the purposes of securing the proper management of the societies, and for housing society particularly, to prevent affairs being conducted in a manner detrimental to the interest of members of society. And after going through this report, if the government is of the view that it needs to be notified, a direction need to be given in the public interest, then the government will come out with a GR notification. That is why 79A notification, as we popularly known as guidelines for redevelopment society, is one of those things. However, 79A deals with elections, it deals with non-occupancy charges, it deals with crop insurance, it deals with many issues. The section says that the member, the committee member or the secretary has to follow the guidelines issued for a particular topic, management of the society. Now, the second part of the provision is that in case of failure of the responsible person to act in accordance with these guidelines, these directives, then what happens? In that case, there is a huge power in the hands of registrar who can disqualify the concerned person for 6 years. He can appoint another person in place of such responsible person, and mind where the person who is disqualified will not be able to act for any other society other than that society for which he has been disqualified for 6 years. And the person who is going to be appointed need not be member of the society. These are the certain extremities. We have to be very careful. Now the person responsible is not the member, but the manager of the society who is an employee. In that case, what happens? In that case, the registrar has a power to direct the committee to remove such person who was responsible for not complying with the requirements of the direction. Then in that case, if the committee fails, a secretary or whoever responsible fails to follow the order issued by the registrar in case of removal of the manager or such a responsible person, then in that case the same consequences follow which were I described in the previous, that manager the member himself was responsible. Disqualification, appointment of another person, disqualification for 6 years, removal of the member, all these issues follow. Apart from that, there is a provision under 146, 147 corresponding, their third member who is responsible can be penalized to the extent of 5,000 rupees. Going ahead, friends, now this is the, what 79A is actually in the statute books. Now, these provisions, I would like to throw light on the aspect of directory provisions or mandatory provision. First of all, I will draw attention to a very old Supreme Court judgment of 2000, when the Supreme Court has laid down, and this is a very important thing, because that Supreme Court judgment, it says that who will decide the interest of the society? The registrar does not have locus standi to decide what is the interest of the society. Section 72 of the Societies Act says that the general body is the supreme authority as far as the management is concerned. In that case, a registrar cannot sit in the chair of general body and decide that this is not in the interest of society or this is in the interest of society. So that Supreme Court judgment has very clearly laid down that the issues can be, the central issue is interest of the society. Most of the time the government comes out with notification by using the word public interest. Friends, let me tell you that Supreme Court judgment has very clearly laid down that public interest cannot be prejudicial to the interest of the society. That means what is paramount important is the interest of the society, and for that the deciding authority, the general body of the society. When I was telling you, Vinod Bhai and Ramesh Bhai, I had in mind this, that there are many aspects, for example, 25,000 restriction, capping of the transfer premium, non-occupancy charges, limited, but all these issues, this particular aspect, I think there will be merit in argument that decision to decide about the interest of the society is that in the hands of the society. And the government cannot hide behind the public interest concept to do away with the right of the societies to decide their own future. Going further, this particular judgment of Supreme Court is followed in very many judgments of Bombay High Court. We are referring to Bombay High Court only because that is what is 79 is interpretation is concerned with. Friends, I will not go into the exact judgment, but I will refer to what has been very important decision following the Supreme Court judgment. To start with, registrar has no power to issue direction to society to appoint a particular developer and execute DA when after GR of 31st October 11, society became entitled to benefit of redevelopment under certain regulations DCR 91, including fungible FSI as per the January 12 circular. It went ahead with executing DA. DGR passed the order under one. Now DGR intervened and said that you cannot go for this DA. The court, considering the ratio of the Supreme Court judgment, came out with very clear that the order of DGR is bad in law and it was set aside. What is the meaning of this, friend? It means the society has a right to go ahead with the DA irrespective of what registrar says. Once a general body decides with a huge majority, a minuscule opposition has to be ignored. Now, when this decision is taken by the general body, if majority member agree and the DA is signed, developer is selected, then there is no role for the DGR under the guise of 79A, because there is no public interest involved in the affairs of a particular society. Another judgment is there, public interest cannot supersede interest of society and non-occupancy charges circular is to be followed by society. In this case, as I said and requested those senior about a merit in the argument about interest of the society, the NOC charges which have been kept at 10%, I believe there is a scope for merit in the argument against that, even though there are many judgments approving the NOC, non-occupancy charges. Another matter, decision, I'll come back to one Supreme Court judgment, not for Maharashtra, but in case of UP, where very important guidelines are issued. These are applicable for our arguments against 79A jurisdiction. Those things are: decision of the government can be challenged on the ground of specific legal provision cannot be violated by this kind of direction or order. Condition precedent does not exist. If there is a guideline or the direction, but the law says that there has to be some condition precedent, then if that condition does not exist, then such orders are not legal. Authority is not competent to give the direction. Order is beyond the legislative authority, and order violates the existing law. These are the very important 5 elements which have again been specified by the Supreme Court in case of UP. And these are very much applicable to all, because that is the law of the land. Now coming back to Bombay High Court, direction under 79A has no consequences. It's very important, everybody has to note down. Direction under 79 has no consequences and cannot derail or alter society's plan to proceed with development as per the agreement executed by society on affirmation of majority of the members. That means if the society has gone ahead with a majority affirming that this is the developer and we enter into agreement, the government cannot interfere under the guise of 79A or public interest. This is the decided case of Bombay High Court. Another matter with regard to this capping of the transfer premium. Society must follow Directive of 25. This is a judgment. However, as I said, there is a merit in the argument against that case. Legitimate right of petitioner to contest election cannot be squeezed or deflected, hence rejection of nomination set aside. This speaks about the direction. The government cannot give such direction which strikes at the root of the right of a member to contest the election, because that right is given by the law. That cannot be done away with, cannot be suppressed, or cannot be deflected by the guidelines under 79A. Friends, I have dealt with entire gamut of the very important aspects, and there will be a long route to fight these issues. In concluding remark, I will finally summarize what I have spoken about. That 79A is a valid provision. In the legal term, we call it a virus or constitutionality. This has been approved by the court of law. That means 79 existence cannot be challenged. Secondly, direction must satisfy the interest of the society. And that interest has to come from the mouth of the society. Society decides what is in its interest and not the registrar or the government. Direction in the name of public interest cannot be prejudicial to the interest of society and its members. This is because I am summarizing whatever I discussed. I have listed this at the cost of repetition. I see merit in argument against transfer premium capping direction which is society decides is not in its interest. If the society decides that we don't want to cap it, yes, in that particular judgment of approval of this 29A circular about limiting the capping of the transfer premium, one of the reasons before the court was unreasonability of the amount charged. Now the society was charging 2 crore rupees for transfer, and because of this huge amount of charge, I think the court had approved. But if it is reasonable, I don't think, but then this is to be litigated. As of today, it prevails that 79A guidelines capping is in place, and it is to be followed by the society unless it is one fine morning contested in the court successfully. Very important aspect, let me tell you, when action is being taken against a member, as I said, 79A, while discussing as to what are the consequences of not following the directive. In that case, one of the reasons is there has to be hearing to be given to the member. Now, normally, as a lawyer, we understand that hearing is a part of the natural justice. But here in 79A, there is an inbuilt provision that hearing must be given, number one. Number two, the federation in which this society is affiliated has to be communicated by the registrar about his so-cause, and the federation has to give consent. Now, If this consent does not come forthwith within 45 days, then in that case it shall be deemed to have been approved, or it shall be deemed to that the federation does not have an objection. Friends, let me tell you, if any of your societies are not part of the affiliated to federation, then please go ahead. However, as a practitioner, and some of you who have approached the federation, unfortunately, the federation, I don't know whether, and you are the better judge, how it is functioning. Guidelines, there are lot many provisions to approach the federation by the registrar. एक remark pass कर देते हैं. ये DGR did not even wait for 5 days to pass the order without federation's approval. So it is necessary for all of you to be affiliated to the federation, and I will go to one step further. Please communicate with the federation immediately when you receive the so-called notice. Do not wait for the federation to call on you. You approach the federation, put your facts before the federation that this is the facts of the case, and registrar's so-called notice should not be approved by you. Then in that case, registrar will be helpless. But I have not come across any case till date, at least, that the federation has intervened and the registrar has stopped the action. Friends, almost I have exceeded by 2-3 minutes, but I have dealt with the topic which I have decided, because this topic is not taken up in this kind of forums. What is being taken up is, Suleimanji is going to address you about actually the guidelines. I was not talking about the guidelines, I am talking of the directory or mandatory nature of the 79A provision. Thank you, friends, for patient hearing.